Welcome to another edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com. Today I'm joined in studio again by Cordell Cordell attorney Michelle Hughes, and we'll be discussing what usually is the most contested part of any divorce case, child custody. So Michelle, thanks for joining me.
Thank you for having me again, Matt.
Now first, almost all child custody determinations are made by using the best interests of the child standard. Obviously these factors will vary by state, but in general, what are some of the most common factors used to determine custody placement?
In Missouri, where I practice, judges take a look at several factors, the most being what the child's wishes are, placement as far as whether the parents have the ability to properly care for the child, the frequency as far as how often the parents actually take care of the child when they're not divorced, whether the parent has engaged in activities that are going to make it easier for the child to remain comfortable in that household, as far as if there are other people involved, other co-siblings, co-parents, and whether or not that's going to impact the child's emotional development. And one of the most important factors is ability to provide a stable household. So if the child, for whatever reason, the parent wants to move or reside in a different location, courts will take a look at that most importantly to make sure that the child's not going to be moved to another location.
Now you mentioned the child's wishes. Is there a certain age, where the judge will just depend on the child, or is it ever, sort of the deciding factor is the child's wish?
I wish there was a certain age, but there isn't. I would say that around the ages of between 12 and 15 are formative years. Child's able to speak for themselves, think for themselves. But still, even at that point, the court will typically appoint a guardian ad litem. A guardian ad litem is somebody that will review all evidence presented by both parties. That person's non-adversarial, so that person is in charge of promoting the child's best interest and giving that information to the court. The child will speak to the guardian ad litem, and usually the guardian ad litem will follow the child's best interest if the guardian ad litem believes that the placement with parent A or parent B promotes that best interest standard.
But a judge won't necessarily always follow what the gal recommends.
Correct. The judge doesn't necessarily follow the guardian ad litem's point of view. I mean, the judge will take a look at the parent's wishes, the proposed parenting plan. The judge will take a look at whether the parent is able to financially afford to provide for that child. Those are several factors that the judge will take a look at.
Now, does the judge always decide custody, or can parents agree to it on their own and will the judge accept what they agree to?
The judge, in a sense, will always be the ultimate determinative factor of custody arrangements. Only because if the parties do agree to a custody plan and the judge decides that custody plan is not in the best interest of the child, the judge can enter a different plan. However, with that being said, it is typically what happens is that the parties agree on their own to a plan, and that's the plan that is entered into the agreement. If the parties cannot agree, then the judge will enter into an agreement for the plan.
So for fathers out there watching right now, how can they go about increasing their chances of getting custody?
I think the best way for a father to promote his desire to get custody or have increased visitation with the child is to show the court that you have frequent, meaningful contacts with your child, that you've had frequent, meaningful contacts with your child throughout the inception of his birth all the way to the point of divorce. It's not that you just want to have contacts with your child now, it's that you've always been a parent. You've always been the parent there who's taken your child to daycare, who's picked your child up from daycare, who's taken your child to school, who's helped with homework. A parent who takes the child to school or stays home from school if the kid is sick. The roles between mother and father should not be only mom does those things and only dad does these things. It should be a very blended role, which makes it easier for the court to say 50-50 custody, if not more, to the father.
Now, once a child custody has been decided, a parenting plan has been put in place, unfortunately, like a lot of dads watching, that may not always happen all the time. There may be people ignoring parenting time or just some sort of visitation interference. So what are the options available to a parent if their custody or parenting time has been interfered with?
I believe there's two really good options available to fathers or mothers, but who have been denied visitation and according to the court order. The first one that I would suggest is a family access motion. Family access motion is a wonderful tool because it's generally 60 days before a decision is made. If you believe you're not getting proper visitation as you should, an order can be filed or a motion can be filed asking that you get visitation. And this family access motion must be heard within 60 days unless both parties agree that they need more time. So that's a quick way to get a result. The other method would be motion for contempt. And this is, generally I like to use motion for contempt in conjunction with the family access motion. I like to hit the party with two different orders or two different motions. And the motion for contempt has a little bit more of a punch because you're telling the court that this person's failure to give you child custody or give you visitation is malicious, it's intent. It's willful, and because of that, you want a stronger penalty. You want the court to award you attorney's fees and costs associated with bringing the motion, where the family access motion is more, not as forceful, it's more, please just let me see my son or daughter. So,
do they ever order makeup parenting time?
Correct, they do, and family access motions specifically, it is part of the statute that you are allowed. If you've missed out on 30 days of parenting time, family access motion must, generally the court will grant that extra 30 days of time that you've missed out on. Motions for contempt, you see that less frequently, although it can be awarded, but a family access motion, definitely you would get that extra time.
That was Michelle Hughes, an attorney with Cordell Cordell here in Missouri, and that'll do it for this edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com.